Good morning, everyone, and welcome. We're pleased to have you with us today. We have 3 cases on the morning docket, and we will call them in the order in which they appear. I should add there was a 4th case, but that has been continued. The Court of Appeals of Tennessee is one court, but the judges were elected from the 3 grand divisions, and we're honored to have with us Judge John McClarty from the Eastern Section today, and we've assigned him all of the difficult cases. And so if you think your case is challenging, then it's his case. I want you to know that. But we're honored to have him with us today. And Judge Bennett and I will have the pleasure of going to Knoxville this year to sit with Judge McClarty and our other colleagues up there as well. Each side has a total of 15 minutes to present your oral arguments. That applies whether there's one attorney or multiple attorneys arguing. If there are multiple, you'll need to share. The appellant has the right to reserve up to 5 of your 15 minutes for rebuttal. So when you come to the podium, after you've introduced yourself, please tell us how many minutes you wish to reserve, and the clock will be programmed accordingly. Are there any announcements or introductions? Hearing none, please call the first case.
Leslie K. Jones, First Tennessee State University.
Good morning, Mr. Winter.
Good morning, Your Honor. I am Gus Winter of the Nashville Bar. I represent the petitioner appellant, Mr. Jones, and I would like to reserve 5 minutes of my time
5 minutes, yes,
for
sir.
rebuttal. Thank you, Your Honor. This is the rare termination for cause Administrative Procedures Act case where the agency's stated position in its notice and statement of charges failed to identify any instances of misconduct. Instead, the agency simply asserted a purported right to terminate Mr. Jones's employment without cause pursuant to contract. Respondent's opening statement again asserted that the termination of Mr. Jones, then Sergeant Jones, was not a termination for cause, but rather was a termination at will. The administrator who terminated Sergeant Jones testified adamantly on direct examination that the termination was not a termination for cause. Collectively, these...
Was that at the first hearing? This case was decided and then went to the Chancery Court, and the Chancery Court remanded it back to the state agency, Tennessee State University, to conduct a for-cause hearing. So was there a second evidentiary hearing at which witnesses testified?
There was only one evidentiary hearing at which witnesses testified. Procedurally, what happened, and Your Honor...
Was that before the remand or after?
After the remand.
Okay. Thank you.
The university refused to grant the requested grievance hearing. So under the particular rule under the APA, through counsel, we requested a declaratory judgment, at which point the agency conceded that there was a right to terminate or to a grievance hearing, a for-cause termination hearing. So then the case was remanded, as Your Honor noted, and the one and only evidentiary hearing took place after the first appearance in Chancery Court.
Thank you. Okay.
The second ground for reversing the Chancery Court's affirmance of the decision of the hearing officer is that the hearing officer's decision was based on a finding that, quote, the totality of reprimands and corrective action caused Tennessee State University to lose confidence in Jones. Respectfully, that's not sufficient. The employee cannot be punished for the same offense twice, and I've cited in the briefing the Finney case, which supports that position on grounds of fundamental fairness. And when one subtracts the reprimands and incident of suspension from the basis of the hearing officer's decision, there's really no substantial and material evidence left.
Let me make sure I'm getting this correctly. Are you saying that each incident at the time they occurred should have been addressed at that point and not over a period of time, the incidents as they built up, then at a period of time, the administration should have just, since they didn't address each at that point, or they addressed each at that point, shouldn't they taken corrective action at that point instead of taking them looking back over a period of time and seeing an accumulation of all the incidents, and then at that point, you're saying they couldn't be used, or what?
I have to give you a two-part answer to that question, Your Honor. The first part is that there were reprimands and suspensions that were imposed upon Sergeant Jones within the same time frame or shortly after they occurred.
Okay.
And it's our position.
Once they were done, then that completed the matter.
That's my position, and I think the Finney case supports that, Your Honor. There were other incidents where there were never reprimands or suspensions, which the state at the grievance hearing introduced by simply introducing records without any testimony, without calling any of the complainants to testify. With respect to those matters, I submit that those matters, there was a failure of producing substantial material evidence that Sergeant Jones actually committed any of the incidents or committed any just cause for termination. But in terms of the hearing officer's decision, he didn't rely on those. He relied on matters that had already been matters from which punishment was imposed. There was also a statement where he says that there were evidence of performance issues that raised concerns. And respectfully, that's not sufficient. It's not. Employers can have good faith concerns about an employee's conduct or performance for all sorts of reasons. But in the context of a grievance hearing where the burden is on the employer to show good cause, merely stating that this was enough to cause concern without getting into the facts and making fact-based determination is not enough. And in terms of the way Chancellor Miles handled this on the administrative appeal, that court's finding below was that the record below indicates that counsel for TSU put forth multiple disciplinary incidents and concerns. That's not good enough either. Again, there's no showing of substantial material evidence of good cause to terminate, and the failure on the part of the hearing officer and the court to identify any specific acts of misconduct that supported the termination decision justifies reversal. Thank you.
Thank you. Mr. Winter, let me ask, your position is if your client was punished or reprimanded for any of these offenses, then those offenses cannot be considered thereafter if he commits, in the view of the employer, Tennessee State University, if he commits another act of improper conduct. So you can't look back and say, and he has been reprimanded 5 times before, and there comes a time when enough's enough. Is that not permissible?
That is. My point is, first, the employee cannot be punished twice for the same offense.
Right.
That's Finney. I think Your Honor is correct that if there is a subsequent act of just cause or misconduct, the agency is entitled to take into consideration previous acts that were punished in determining how to handle the matter. But in this case, there was nothing that happened after the last corrective action which would justify termination, or which could, under any fair and rational standard, be considered misconduct.
All right. Thank you, sir.
Well, what misconduct triggered his termination?
Well, according to the administrator, Dr. Samuels, who terminated Sergeant Jones, there were three things. One was, I'm just going to call it an AWOL incident, where there were a combination of misconducts on the part of Sergeant Jones, which led to a 1-week suspension. And that was corrective action by definition. There was a second incident.
No, what incident triggered this series of hearings and whatever now?
Well, Sergeant Jones testified that he was told he was being terminated because of issuing an e-alert. The agency never acknowledged that. They did see in the grievance hearing report or grievance request that Sergeant Jones stated, "This is why I got terminated. This is what the chief of police told me as to why I was being terminated." In the course of the grievance hearing, Chief Brigance testified he didn't remember the incident, but he acknowledged that he contemporaneously had read Sergeant Jones's statement requesting his grievance and still felt that Sergeant Jones should be terminated. From the record, that's the incident that immediately led to the decision to terminate.
Thank you.
Thank you.
Thank you, Mr. Winter. Good morning.
Good morning, Your Honors. May it please the Court. My name is Camille Volcano, and I, through the Office of the Attorney General, represent Tennessee State University, which is the appellee in this matter. The state's primary argument is based on these straightforward facts. These facts are that appellant was an at-will employee of TSU and was terminated by TSU in full compliance with the terms of his contract. Both the hearing officer at the administrative level and the chancellor found that there was substantial and material evidence in the record to support the finding that appellant was validly terminated based on his at-will status and upheld the termination.
Now, wait a minute. I thought you just said he was terminated as an at-will employee, but then you said there was substantial material evidence to terminate him. Are you proceeding on two different bases or one? Because I'm of the impression this appeal comes from a determination in a grievance hearing that was not based upon at-will employment. Am I wrong?
Your Honor, TSU's consistently maintained the position that the appellant was terminated as an at-will employee.
But did you not concede in the first Chancery hearing that he was entitled to a grievance hearing?
Your Honor, the reason that the state...
It's a yes or no answer.
No. No, Your Honor.
The state, so even though the Chancellor says in its order, the state conceded that he's entitled to a grievance hearing and agreed to the remand, the Chancellor's dead wrong.
Your Honor, the grievance hearing was not necessarily for a for-cause termination. The reason that appellant was entitled...
Please keep this case simple. Did the Chancellor say he was entitled to a grievance hearing, remand the case to Tennessee State University, and did Tennessee State University conduct a grievance hearing?
Yes, Your Honor.
At the end of the hearing, did they say that there was just cause to terminate, good cause to terminate?
Yes, Your Honor, in addition to finding that the appellant was terminated pursuant to his at-will contract.
So that was an additional basis after the remand?
Yes, Your Honor.
Okay, all right, thank you.
Of course. At the
What was he terminated for?
Well, Your Honor, the appellant was terminated in pursuant to the terms of his contract. So when he was giving his notice of termination, he was told that he was given 14 days notice, that his employment would end, and he was paid for his accumulated leave.
So was there something that triggered this? Or did they just decide they didn't need him anymore?
Well, according to the notice of termination, there was no cause that was listed in his notice. So the actual termination itself was just in pursuance to his contract.
Okay.
At the administrative level, the hearing officer acknowledged and made part of the record the contract, its terms and conditions, the notice of termination, and confirmed that the appellant was an at-will employee. At the Chancery Court level, the Chancellor found that there was substantial material evidence in the record to support the appellant's termination based on his at-will contract. The contract was entered into evidence as TSU's Exhibit 3. The contract states that the appellant could be terminated on 14 days' notice. TSU gave proper notice to the appellant through its notice of termination that stated that appellant's employment would end in 14 days and offered him payment for his accumulated leave. All of this material evidence was made part of the record at the administrative level and was recognized and affirmed by the Chancery Court. Your Honors, this case can and should be resolved based on these straightforward facts alone because there is substantial and material evidence in the record that supports them. And in the appeal...
Why does there have to be substantial and material evidence if he was terminated as an at-will employee?
Your Honor, because the need for substantial material evidence is the standard that is before this court today.
I'm aware of that, but the state's position is that we could just terminate him for no reason.
Correct, Your Honor. And
So why do you need substantial and material evidence?
Well, the substantial material evidence is the contract which would support that position.
So the at-will contract requires substantial and material evidence of malfeasance or misconduct or what?
No, Your Honor.
What is the basis for terminating this gentleman on an at-will basis?
The contract itself, Your Honor.
The contract is the evidence.
Yes, Your Honor.
And it requires no substantial and material evidence.
Your Honor, it's the state's position that the contract itself is the substantial material evidence that supports the state's primary argument today.
Okay, all right. So
I apologize for not making that
but
clear.
your position, sometimes I like to be just as straightforward as possible. Your position is he was terminated as an at-will employee, period. We didn't need a reason.
Yes, Your Honor.
Okay, thank you.
As I was saying, Your Honors, this case can and should be resolved based on these straightforward facts alone, because there is substantial and material evidence, the contract itself, in the record that supports them. And in the appeal record presented to this court, this evidence has not been challenged. No other evidence is necessary to affirm the findings of the hearing officer and Chancery Court that the appellant was validly terminated pursuant to his contract. However, acknowledging and responding to appellant's argument, the record also contains substantial material evidence that supports an alternative finding raised by the appellant as to whether the record supports a cause termination as well. That evidence was described in detail not only in our brief, but in the final order of the Chancery Court. But for today's purposes, it is unnecessary for this court to make determinations regarding any of that evidence related to separate findings for cause, because the state's primary argument, which has been recognized and affirmed by the lower courts, is supported by enough substantial and material evidence in the record for this court to resolve this matter in its entirety. And for that reason, the state requested it do so.
And again, the substantial and material evidence is the at-will contract.
Yes, Your Honor, including its terms and the recognition of that evidence by the lower courts.
And that requires 14 days notice, nothing else.
Yes, Your Honor.
Okay, all right, thank you.
Of course. May I answer any further questions from the court?
Hearing none.
Well, acknowledging no further questions, the state requests that this court uphold the termination based on substantial material evidence in the record.
All right.
Thank you, Your Honors.
Thank you. Mr. Winter?
Waive rebuttal, Your Honor.
Well, I'd like to ask you some questions. I have to admit, when I read the two briefs, I was confused as to, it some point, I think it's an at-will employment case. Then at some point, well, there has to be substantial material evidence and so on and so forth. The state's position is now clear to me. I may not be stating it correctly, but in my view, their position is we gave him a grievance hearing, but the bottom line is we terminated him based upon an at-will employment contract that only required we give him 14 days notice. What do you say to that?
I submit that that argument fails as a matter of law, and there's very little case law on TCA section 49-8-117, which gives support staff employees at Tennessee Board of Regents institutions a right to grieve their dismissal for cause.
Right.
But the one case that I think supports the position of Sergeant Jones and repudiates the position advocated by the state this morning is the Lawrence versus Rollins case, which states that by act of statute, the presumption of termination at will can be changed. And that is what the Tennessee legislature did with respect to support staff employees such as Sergeant Jones. And it's unrebutted in the record that Sergeant Jones was a support staff employee who fell under the umbrella of the protection of that statute.
And that statute is 49-8-117.
Yes, Your Honor, that's correct.
I wish you'd raised that in the other part of your argument so that the state could have replied to it.
Well, I'm sorry if that was certainly no attempt to mislead. I would say two things. One, that was very much part of the reply brief after TSU cited the Lawrence versus Rollins case. In reply, I submitted argument that Lawrence versus Rollins actually supported Sergeant Jones's position in this case rather than Tennessee State's. And the second part is, as I read Chancellor Miles' decision, she, as I read it, took the position that this was not a termination at will case, which the combination of these factors led me to state that we would waive rebuttal. But again, if there are any other questions, I'd be happy to respond to them.
Hearing none, thank you, Mr. Winter, and thank you for answering my question.
Thank you, Your Honor.
Call the next case, please.
Pepper Black et al. Versus Teresa Baldwin.
Mr. Blackburn, if you'll give us a moment so we